All right, I'm having trouble with my live stream. I just wanted to let you know they had put in a new computer yesterday, and I'm having to go through a lot more steps to get things working today. Just to let you know what's going on.
Good morning, Your Honor. Thank you for apprising us of your technical difficulties.
Would you print me a docket? I just got this marked up one, and I'm not sure how accurate it is.
Judge, I can't print out a JIS yet.
Oh,
My printer
okay.
works, but I was just working on that before you showed up.
Okay, I'll wing it. Shannon, could you print me today's docket?
Yep.
Thanks.
I'm talking to IT about it.
I am having trouble live streaming. It's timing out. Let's try one more time. Oh, that says stop live stream. But I don't think I'm streaming. Do any of you have my YouTube channel open? Can you see if anything's streaming? Apparently not. Why don't you try it? See if you can pull up my YouTube channel. It's telling me to stop live stream where it normally says start, but I don't think it ever started.
I can see it streaming.
It is streaming. Okay, good. Shannon, can you put us on the record now? Okay, first up is Schaefer versus Spencer. Counsel, state your appearances, please.
Michael Fallahy on behalf of the plaintiff here.
Jacqueline Garris appearing on behalf of Mr. Spencer.
Ms. Garris, this is your motion?
That is correct, Your Honor.
Go ahead.
Okay, so I think one thing we do have settled is the matter of child support being referred back to the front of the court for a review. And any modification retroactive to the date of filing my motion. So if that's fine with Mr. Fallahy, which I think it was in his answer, that we'll check that off the list of things in my motion.
Okay.
All right, so the other two matters have to do with parenting time. The first issue is that pursuant to the prior orders of the court, my client is entitled to share equally the summer parenting time. This year, obviously, unusual circumstances for everybody. The child normally would get out of school on a Friday for the past few years, and the parents were able to split parenting time through the weeks. This year, the child got out of school in March, but attended virtually until June 10th. And we consider that to be when the school summer started. This child doesn't go back to school until August 26th. So that would be 11 weeks. Pursuant to the order in 2016 and 2017, the parties are to share those. My client always gets the first week, and the mother always gets the last week, unless there are an uneven number of weeks, and then Ms. Schaefer would have only half of that last week. So that's what's happening here. The child gets out June 10th. She doesn't, my client is not allowed to have the child until that Sunday. So in effect, Ms. Schaefer had the 10th through the 14th. And then the child, when she goes back August 26th, My client actually has a summer break from August 9th to August 16th. He should have those extra days to make it the equal parenting time until August 26th. So that's where we're at with this. It's equal parenting. I think there's going to be a debate as to when summer really started. In the prior orders, it's that summer, it started after a school ballet recital. And if not, then on a Sunday, but that was always when the child got out of school. This year, obviously no school ballet recital. So my client is actually losing time. He's losing a whole week, in fact, with the child for summer parenting time, because he should have had either some week on the, sometime on the front end between June 10th and June 14th, or on the back end, August 14th through the August 16th through the 20th is what we're requesting. So statements that the child says she feels safer with my clients. This was an allegation also that Ms. Schaefer made to my client back in earlier for spring break. Child has no problem with father. He has a great relationship with the child. It's the child's inherent right to have parenting time with each parent, not the parents. So to say a child is afraid, unless there's abuse or allegations or neglect or anything like that, I mean, it just seems like she just doesn't want the child to spend time with the father. So that is what I'm requesting first, is as far as the summer parenting time to make up. So my client is requesting Sunday, August 16th, which would tail on to the end of his summer, because they each get 2 weeks of summer break. So that would tail on to his week, August 16th to August 20th. And then we approach where we're asking for the week on, week off to continue, because the child, I think, is going to be attending virtually. I don't think it's a certain thing, but if it is, my client would like to continue the week on, week off. He's a dad that works at home, so he will be ready and able to have the child sign on for school, help her with her homework. He's perfectly capable, just as Ms. Schaefer is. Again, unusual circumstances, and that is the proper cause or change in circumstances to meet the threshold here, because child isn't going back to school virtually. If she is, then that's a moot point, but we believe that she's not going to be going back to school, as they say, in real life for the near future. So if that is the case, we would like to continue the week on, week off.
Thank you. Mr. Valley?
Thank you, Your Honor. Judge, the way I read the order from 2017 is it amended the order from 2016. I referenced it in my client's response, but paragraph 5, page 2, order from 2017 clearly indicates that, and I'll quote the order, in the event there is no ballet recital, the regular parenting time weekend rotation shall control, with father's summer parenting time starting on Sunday evening at 4 p.m. So regardless of the circumstances this year, the court order that's in place covers this exact scenario. There was no ballet recital, and so Mr. Spencer's parenting time was due to start on the Sunday after school would have let out at 4 p.m. That's the reason my client didn't allow the initial summer parenting time, is because she was following a court order. She should not be penalized for that. I think the language in the order from 2017, if read in conjunction with the language in the order 2016, it lists the exchange days as Sunday at 4. And so if the last week of summer parenting time to end, it would, in my client's opinion, in my opinion, would end the Sunday before school is due to resume again at 4 p.m. And when that, after you get to that Sunday, then the regular weekend rotation shall control. That's the way that I would read the order 2017 and 2016. So while the order from 2016 does say equal parenting time in the summer, the order from 2017 amends that, and the equal parenting time is defined, in my opinion, as Sunday after ballet or after school lets out until the Sunday before school begins. In this circumstance, it would result in 10 weeks of summer parenting time, It's a pretty easy math equation there, 5 weeks for each party. That's what my client is following, and she's done that on my recommendation. Relative to the request to continue week on, week off, if school were to be held remotely, that would amount to a change of custody. There's nowhere near enough evidence in this case to justify changing custody. If this whole school year, and hopefully it won't be, but if this whole school year is held remotely, and the child, for example, were to live week on, week off with these parties, that is undoubtedly a change in custody. So it's our position that there's absolutely no change in circumstances, no proper cause to change custody for the court to even get to the potential consideration of clear and convincing evidence to do that. So our answer to the motion was pretty clear. It's our position that we feel that the request to change parenting time, the request for summer parenting time and to change custody relative to the school year, frivolous. It's not based in law, and we'd ask the court to find that way and order $1,500 in attorney fees to my client. As Ms. Garris indicated, we did stipulate to a referral to the friend of the court for the reasons indicated in our response to the motion. So that's our position, Your Honor, and we'd ask the court to enter an order accordingly.
Your Honor, may I reply to that?
Yeah, I have a question for you first, because I understood your argument with respect to whatever happened to the summer schedule resulted in your client being denied equal parenting time during the summer. Is that is that inaccurate? Did he get less parenting time, or would get less parenting time if we follow whatever the existing order is?
So yes, my argument is yes, that there are 11 weeks, and pursuant to the order, if there are an odd number of weeks, then mother only gets the half of the last week, and she's taking the whole last week, and she took the whole first week. It's a subject to interpretation as to how many weeks there actually are. I think that's where we're differing. The other side says there's 10. We're saying there's 11 because we're counting from the day that she got out of school, which was a Wednesday. In the past years, the child always got out of school on a Friday, so there was not this debate. But she got out on a Wednesday, so Ms. Schaefer got from Wednesday, Thursday, Friday, Saturday, Sunday, and then we'll get her back Sunday, Monday, Tuesday, Wednesday when she gets back to school. So we're stating that there are 11 weeks. And again, the child always got out on a Friday. She got out on Wednesday because everything has changed this year because of the pandemic. The 2017 and 2016 order never contemplated there would be these kinds of circumstances here. So my client has asked for that time. He has been by Ms. Schaefer. So to make it fair, pursuant to the order, equal parenting time means equal parenting time, and we're considering 11 weeks. And pursuant to the order, Ms. Schaefer would only get half of the last week. Also, that's an answer to your question. If you want me to also reply to Mr. Falahi's argument about.
You certainly may.
Okay, so this is not a change in custody. It's not a request for that. It is a modification of parenting time if we were to go forward with the week on, week off, if the child doesn't go back to school. So the proper case is not Bud Barker. That's not the standard. The standard would be Shade versus Wright, because we're just asking for a modification of parenting time. This does not amount to a change in custody. The burden is not clear and convincing evidence. It's a preponderance of the evidence, because this would not change the established custodial environment of the child. So that is our statement about that. It's just that the threshold is that there has been a change in circumstances. Let's just assume child's not going back to school in real life come August or September. So that change in circumstances, and we're asking for a change in the parenting time on a temporary basis. And then, so the standard is not clear and convincing, but it's by preponderance of the evidence. It's a lower bar We're not using the VARCA standard and asking for a change in the established custodial environment or a change in custody. We're asking for a modification of parenting time, and that's by the preponderance of evidence.
Okay, thank you, counsel. With respect to modifying parenting time, whether it's a modification of parenting time or a change of custody, I am not opening that door to have every custody case come into my court and ask me to modify parenting time because of coronavirus and remote schooling as opposed to in-person schooling. So as to that portion of your motion, I am denying it. I do believe that however you calculate it, the intent clearly was that the parties have equal parenting time during the summer, and whatever needs to happen to make that happen, I am ordering.
Thank you, Your Honor. So to be clear, we're asking for August 16th through the 20th. Is that what the court is ordering at this time?
Well, let me ask Mr. Fallahy, would that indeed result in each parent getting an equal number of overnights during the summer?
I think it would, Your Honor. However, I mean, I guess you'd need to make a finding then that the definition of the summer, because this issue is going to arise again. And so, or at least I would anticipate that it will based on my involvement in this case. And we'd have to set aside the language, I think, specifically in the 2017 order that I believe was a consent order in order to accomplish what the court's indicating. Obviously, I respect the court's decision. And I think that the extra 4 days would result in exactly equal parenting time for the summer. However, I don't think that's what the current court order says. That's the issue. So we'd have to amend the 2017 order to prevent this issue from coming up again as well. So I just wanted to bring that to the court's attention.
Your concern is noted, but that is what I'm ordering.
Thank you, Your Honor. I will prepare an order. Mr. Fallahy, I'll send it to you for your approval.
Great. Thank you very much.
Thank you.
Thanks, Judge.
Thank you. Ms. Dinky, what matter are you here on?
Aldrich, I've got a pretrial.
Oh, okay, that's not till 9:30. I knew you had one at 8:30 that got pulled, and I just wanted to make sure you weren't confused.
Nope, I am confused. Thank you. I was thinking they were both at 8:30. Thanks, Judge.
Okay, and is everyone here on Tanner versus Tanner? You're muted, Mr. Navarre.
Apologize, Your Honor. Paul Navarre, appearing on behalf of plaintiff Sean Tanner.
I'm here.
My client is appearing by phone and she's present, Your Honor.
Ms. Duncan, is it you on the telephone or is that someone else?
That's me. I'm Sean Tanner.
All right.
Can you hear me?
Yes, I can.
Okay.
Shelley Duncan filed an appearance, but she hasn't shown up yet. So I don't know what's happening there, if they're having some trouble. I've got to take a brief adjournment anyway. I've got a video appointment at 9 o'clock, so that's going to start in about 4 minutes. So I'm going to go off the record. I will leave the meeting room open. I will stop the live stream, and as soon as that's done, I will come back on the record. And hopefully Ms. Duncan will be here by then. Mr. Navarre, if you could maybe shoot her a quick text or something and find out where she is.
I will, Your Honor. Could you put my client and myself in a breakout room, Your Honor?
Okay, and she's the one on the telephone number?
Yeah.
You know, Your Honor, never mind. I'll just go in the waiting room and I'll communicate with her by phone.
It's easy to do. It's easy to do. I don't mind.
It's okay. I'll reach out to Ms. Duncan and we'll be back when Your Honor